Good morning. It's time for the Thursday morning live stream. I'm Mitch Beinhacker. I'm a business attorney in Clark, New Jersey. I work with business owners generally on a monthly subscription basis, where you get my attention and time and expertise based on your level of subscription agreement and discounts and things like that. Also, an online vault to keep all your documents available to you, organized, and have me have a better understanding of your business. For those of you who follow me regularly, you know my problem with ad hoc legal services and how you get poor results for your business, trying to deal with problems as they arise and not having a business attorney really understand the workings of your business and are you set up and your agreements in place and in insurance, risk mitigation, governance of your business, how it's structured, so forth. So that is the way to work with a business attorney. I will put a link in the comments to more information on my website. You can also text law to 21,000 to get my digital business card. And I hope that you listen to me on the Accidental Entrepreneur, the small business owners podcast, where we interview entrepreneurs, startups, other small business owners, authors, small business influencers around the world to share their ideas and help you get a hold of your business. And be sure to support our sponsors. Now Site Marketing is a marketing website that allows you to, with a couple of clicks, get a hold of all your digital marketing. Check them out, nowsitemarketing.com. And the digital business card that I have, Digital Accelerant, is something you ought to look at too, especially in light of COVID. Nobody's going to be touching your business card anymore. You're going to need an electronic version, and that's what this is. And as well as Fetch Internet, which is a secure, high-speed way to turn your phone into an inexpensive or free hotspot. So I will also put links in the comments in this video. Today, I'm going to talk about commercial property leases. There's a lot of things going on right now. Businesses are downsizing. Landlords are going to face, at least on the office space side, a lot of challenges in the coming months and years. I've heard of large corporations dropping their space by half or sometimes two-thirds, moving employees out to satellite locations so they can use different space, sharing space on different days and so forth. And you're going to also find small business owners are going out of business, and there's going to be a lot of space, retail, office, restaurant, things like that. But unfortunately, when one falls, another one stands up, and there are opportunities that come around with business owners that do have the cash or do want to start a new business or looking to rent a space as rents drop and so forth. So I wanted to spend some time today talking about the kind of things that you should remember when dealing with a landlord and a commercial lease. I get a lot of situations where people go to rent space. Maybe a realtor or broker shows them the space and they get the lease from the landlord and they sign it and they give them a check and they're off and running. Do not sign a commercial lease without having an attorney review the lease agreement. Just because the landlord's presenting it to you does not mean that you can't make changes. And there may be things in there that you're not aware of that will come back to haunt you later on. Things like price escalations, things that you're responsible for that maybe you shouldn't be responsible for. Now, remember, when it comes to commercial leases or any contracts for that matter, everything's a negotiation. It's all about leverage, right? So if this space is in high demand, it's in a high traffic place, you may not have a lot of leverage. The landlord may have choices where he says, listen, I'm not changing the lease. This is what I offer to my tenants, and you can rent it or I'll rent it to the next guy. But it may be the opposite of that. It may be an office space where they're going to have trouble renting out the space and they're making deals with people. And those are the situations where you have more leverage. Also, there's plenty of landlords that are totally reasonable and they're fine to change things to accommodate you. They want happy tenants to move in. They want you to start off on the right foot. So don't assume just because you're given a lease agreement that it encompasses everything and represents your interests. Because unlike residential tenants, which have a lot of protection under the law, and if landlords don't include certain clauses and design the lease certain ways, the tenants may in certain situations have more rights than the landlord. And the laws are very onerous on landlords. They got to follow a lot of rules. That is not true in the commercial space. It's a arm's length business negotiation. If you go to evict a commercial tenant, you don't even go to landlord tenant court. You go to chancery court. It's not a landlord tenant matter. So let's talk about leases. Obviously, every lease is going to have a term. It may have an option, and I would always ask for options to increase. You're better off if you're a newer business taking a shorter term with maybe one or two options, maybe 2 or 3 years with 3-year options. If you're more in business for a longer time, you may want a longer lease because that may add to the value of your business. What happens if you go to sell the business one day? The business owner or the purchaser is going to say, well, what kind of a lease do you have? And if he thinks that in 6 months, a year, 2 years, you're going to get thrown out of the space that you're in, it reduces the value of your business and adds risks to the buyer's situation. So you got to weigh those two about what your commitments are, the value of a long-term lease versus a short-term lease, and what options you have. Leases often, not often, may also include, depending on the situation, an option to buy the premises. Maybe it's a smaller building, maybe it's a big warehouse, and you think at some point you'd like an opportunity to buy the building. Maybe the landlord's older, he's looking to get out of this building. And you may ask him, are you willing to consider an option for me to buy? Some will. So don't overlook it. You may want to ask for some credit of the rent towards the purchase price over time if you execute. There may be a period of time in which you can execute an option to purchase. But pay attention to those. I've been in many, many, many situations where people had options to purchase a business or a building at a certain price. The market turned around and went up, and they had an option to buy it at a much lower price, and they didn't execute the option in accordance with the provisions in the lease. Usually you have to execute the option in writing to a certain address. You got to do it within a certain time frame. And if you don't do that, and the building that you were going to buy at $1 million is now worth 5 million, you can be sure the landlord is going to hold you to that and say, well, you didn't execute the option properly, and we'll sell it to you, but we're selling it to you at fair market value, and you just lost your option, which you may have paid a price for. You can tell the landlord, listen, I'll pay you a certain fee in order to have this option. So don't overlook those things. You also want to pay attention to the lease that might have some hidden escalation clauses with rent over a period of time. Seen situations where your rent is a certain level, and then down the road, especially with people that are buying a business, you want to make sure you review the lease because it may contain escalations after 3 years or 4 years or so forth, and what those escalations are going to be. Or if it renews, does it renew at an escalated percentage, or is it just fair market value when it renews? And then you're in an argument as to what that is. And that may be okay. Just be aware of what it is. Another concern, and I find it very lacking in a lot of leases with smaller landlords and smaller spaces, not necessarily large landlords as much. So when you lease a commercial space, if there's multiple tenants, or even if there's not, there's often a charge by the landlord for common area maintenance, maybe a lobby, maybe outdoor space, whatever. And the landlord's incurring plowing, lawn mowing, landscaping, cleaning on a regular basis. And he or she's going to apportion those costs to the tenants. So if there are 4 or 5 tenants in the building, let's assume all the spaces are equal. You'll probably pay 1/5 of the cost of the common area charges. What's often missed is a provision that allows you to question those charges and what I call true up the cost of those charges. So you want the right, first of all, to see the bills that are being attributed to the increase in certain costs. Usually what happens is a lease starts with a common area maintenance charge as a base cost. So maybe it's $2 a square foot. And then after that, it would increase each year based on real estate tax increases, based on increase in the cost. Maybe there was an extra plowing bill because it was a bad winter with snow. The landscapers increasing their bills. Maybe there was more coronavirus, right? So buildings now have to incur more costs, and they're cleaning common areas more. They may pass that on to the tenants, and they may have the right to. Now, because of the pandemic, some may not do that, or they may pass on part of it. But you should have the right in your lease to review all of those increases to confirm that what the landlord's passing on to you is correct. You also want to have provisions in there that require the landlord to notify you, let's say within 3 to 6 months of the end of the lease, of these increases. And if they fail to do so, that they lose the right to pass on that increase to you for that particular year. I've had clients that have gotten surprise letters from the landlord and said, oops, We forgot to send you these increases for the last 10 years. And can you write us a check for $50,000 or $100,000, of which most small business owners who work on cash flow do not have. So don't overlook that. It's very common that there's no dispute provisions, that there's no onus on the landlord to stay on top of the increase, that they're just paying them. And next thing you know, they're like, oh, well, you can just write us a check. You have all kinds of money. A lot of business owners do not. They work on cash flow. So that's very important. And it should be a part of the lease that is addressed early on, because it leads to lawsuits. It leads to misunderstandings, and leads to problems with your landlord. And very often the landlord has more leverage than you do. So make sure you have that in the lease. You also want to pay attention to the things that may be passed on to you. There are things like capital improvements, like the replacement of a roof, or the building needs new windows. That improves the property. And if I'm representing the tenant, I don't want that to be passed on to my tenant. The landlord gets to keep the roof and benefit from it, and the windows. That's different than increasing the cost of maintenance. So you want to make sure that the lease differentiates between the two, right? If the parking lot, for example, needs to be repaved because the tenants are using it and breaking it up, maybe that is regular maintenance. But the roof wears out just from time, and it's going to wear out whether you're there or not. So you want to make sure you negotiate those things up front. You don't get hit with the landlord says, oh, you know what, we're going to replace the roof, and now we're apportioning it to all the tenants. You can go back and say, no, wait a second. We're not responsible for capital improvements. We pay increase in maintenance costs. And the definition of those things is very important as to what a capital improvement is and what a maintenance cost is. And you better make sure in a lease that is clearly defined. Also, very often with small landlords, they may want a personal guarantee because you may have a small business and you don't have a lot of assets in the business. Now, there are plenty of situations in the professional marketplace, in the larger space, where they don't necessarily ask you for a personal guarantee. But if you're a smaller tenant, they might. I would ask for something called a good guy clause, meaning if you got to go out, you got to move. If you help them and are cooperative with them, giving them access to the space to bring a new tenant in, that it doesn't trigger the personal guarantee. It's only if you walk out in the middle of the night and screw the landlord. A lot of landlords may consider that. They certainly wouldn't offer it up. So there's ways to do a personal guarantee, but if you're cooperative, let's say you're having business troubles and the business is going out, the last thing you need to do is deal with a lawsuit from the landlord who's probably suing you for money you don't have. So if you're cooperating and you're shutting down the business and you give the keys and you don't make it difficult to get into the space, the good guy clauses apply. You may also have issues where if you left the space, you can't open the same location within a certain distance of the building. So you know that you're not competing with them for space, just moving your business around. So good guy clauses can be designed to do different things. If I talked about purchase options, so I think I covered everything basically that I want to. But just make sure that when you get a lease from a landlord, you read it carefully. Not just have your attorney read it, but that you read it and you understand it. And if there are escalations in there, that you calendar those out so you know that they're coming. Now, by the way, escalations are a very good way to get into space maybe where you can't afford to be in the space. Maybe you can only afford to pay $18 a square foot. The going rate is $22 a square foot, and the landlord's willing to work with you. So you go to him and you say, listen, let's pay 18 for 2 years, 22 for 2 years, and 24 for 2 years. Okay, because as your business grows, you should be able to deal with the increases. You obviously have to make that determination. But you also, now the landlord is getting his $22 on average over time. So he's just playing with time value of money, and he may be willing to do that. Also, you may want to talk to the landlord about a buyout. About build out, right? So sometimes landlords will give you space in what they call a plain vanilla box. They give you the walls, sheetrocked, basic flooring, the plugs and electrical switches, things like that to code. If you want to upgrade that, that may be at your cost, but you may not have the money to do that. So you may go to the landlord and say, hey, listen, if we add $5 a square foot to the build out, would you be willing to pay for the build out? We'll pay it over time. And you may have to sign a note for that you owe the money, but you can pay it over time. Also, some landlords will give an allowance for build out. They'll say, listen, we'll allow $9 a square foot. And if anything over that, we'll allow up to $20 a square foot, but you're going to have to sign a note for it and it's going to add to the rent. So there's a lot of creative ways to get into space if a landlord's willing to work with you. It's not all, plain vanilla, this is what you get. Some landlords are not willing to do that. Other landlords are. But they recognize that getting you in the space and getting a tenant in there who's happy, who's profitable, who's productive is better for them than having vacant space. You also may want to upgrade certain things. So if the landlord's putting in basic, um, carpeting or flooring, you may want to upgrade that. So, that would be an upcharge that you would add to the square footage. You could also go get a business loan and just pay the landlord. You also want to pay attention to, though, what you can take and what you can't take. So a lot of these things that you're paying for in terms of the build out, you have to leave, right? You can't take the carpeting that's been attached to the floor. Or if you put up, what's a good example? Glass walls in a building, those tend to be thought of as fixtures, depending on how they're installed, which, by the way, the landlord can accelerate depreciation. So that's something to bring to his or her attention. But generally, you can't take those with you. So those things are going to have to stay. And install the kitchen, for example, probably has to stay. So sometimes it's going to benefit the landlord to have the space built out as well. So you want to negotiate that. If you need a basic lease, you can go to my website. I'll put a link in the comments to pay for one and pull one down. If you need something reviewed, I charge a flat fee to review most leases, depending on the length. So I'd give you a price then. Or if you need a sample lease, please contact me via email. I'll be happy to provide you with a standard lease with some basic provisions for a discounted fee. So I think that covers it for today. So this is a topic and an issue that people are going to have to deal with moving forward with everything that's going on in the economy and the pandemic and how it's affecting space. I think we're going to see problems in office space and opportunities in distribution space, warehousing space, storage space, those kinds of things. I'm Mitch Beinhacker. This has been the Thursday morning live stream. Actually went a little over today. Listen to me on the Accidental Entrepreneur, available on all the podcast directories. And you can always visit our website, beinhackerlaw.com, to learn more about our products and services. Thanks for listening. Enjoy the rest of the day and the weekend.